I'd like to, this is another perspective here, which I think is sort of, for those people that are interested in this sort of area of the discussion, I'd like to introduce our next speaker, which is Radhika Bal, if I've got that right. Radhika is a practicing lawyer in Delhi and other parts of India. She runs her own practice called Family Law Care. She's assisted international parents for a period of over 6 years. She has supported many Australian parents on their exit visas, has worked across India and has supported some 200 families. So certainly from an Indian perspective, I think Radhika would be a very interesting sort of speaker for us, and welcome you all to our program here today.
Thanks a lot, Mark. Hello, everybody. Let me introduce to our panel of speakers. We have with us Ms. Poonam Jain from India. Poonam has worked with diplomatic mission for the last more than 20 years, and she's worked under various departments like immigration and fraud, citizenship and passport. Poonam helps the parents. She has a vast experience and knowledge, so she helps the parents with the proper documentation that would assist them in getting the citizenship of the children and taking them back. She's been helping the parents with the exit visa formalities also. Poonam and her company under the name of Prime Air Global has assisted several parents from Australia as well as other parts of the country. We also have with us Mr. Roman Diona. Mr. Roman Diona is a principal migration advisor for Far and Wide Migration, a Sydney-based migration practice specializing in citizenship, family and business sponsored visa. He is the president of the Gay and Lesbian Immigration Task Force and previously served as a state secretary of the NSW at branch of the Migration Institute of Australia. So please welcome them. And we Now we have the questions at hand with related to immigration, and also we would look forward to hear from you if you have any queries. I would like to ask from our panelists that what are the requirements for the Australian citizens to get the child born overseas to get the Australian nationality?
I just would like to say that the Citizenship Act is very clear. At least one parent is Australian citizen at time of birth. Couldn't be any simpler than that. That is good and bad. Good because it's very clear. At least one parent is an Australian citizen. But because it's briefed, the differences in experience, be it India, Thailand, USA, Canada, South Africa, Europe, is due to the fact that our good friends at the department are, you can quote me on this, making it up as they go along. So, there would be no uniform process of achieving citizenship by descent. It is also important to understand that citizenship by descent is only applicable to you if, obviously, at least one parent or the biological parent is Australian citizen by descent. But what if it's only a permanent resident visa? Then Citizenship Act is not relevant. It is Migration Act. Also, when you're talking about passport, Citizenship Act is not relevant. It's a passport. I'll elaborate on that a little bit later.
Yes, Poonam, would you like to add something to this?
I would refer to what he said because I have the practical experience of assisting many parents by putting their package together, and it's the same thing, we apply these acts. If it is a citizenship, then we apply the Citizenship Act, and as he said, if the parents are permanent residents, we apply the Migration Act. That's really true.
Yeah. So in all, what we would like to say is that it's very simple, that at least, there's not much criteria that we have to meet. It's basically one of the parents should be at the time of the birth an Australian citizen, but then there comes a question that is the parent who is an Australian citizen should be biologically related, or would it do if the parent is not biologically related? I'll put my question like this, that a couple, both of them are Australian citizens, but the one who is biologically related is not an Australian citizen, right? So the non-biological is an Australian citizen. So in this particular case, will the child get the citizenship, still get the citizenship of Australia, or the child has to get the visa under the or dependent visa on the basis of the non-biological child being a parent?
Let me go back to the making it up as they go along provision. There's a big, what they would like to do is DNA. That's been the genetic link is the traditional way to determine the parent-child relationship. But as we heard from other speakers, that is not the exclusive way or exclusive means of proving the parent-child relationship. Now, in US, for example, there's no DNA test because there are robust court processes in US that gives comfort to the decision makers. In India, however, because there's no such process, then they rely on DNA test. So it depends really on the country that you are doing it. I do confirm to you that even in absence of biological link, late December there was a case where it turned out there's no biological link, and we were able to get that across the line. What I can say to you is that our friends at the department are sympathetic. What is important is to seek advice as early as possible, so that where there are complications, we'll be able to fix the problem.
Yeah, very well said by you. Since it's a sensitive procedure, apart from the medical things, we also have to look into the legality part of it, because after the child is born, it becomes the responsibility of the parents to get the nationality and get the child back to the country. So it is very important that before you start, enroll for a program, please see what criteria you're meeting and what are the obstacles and what are your factual position. Consult with a legal professional or an immigration person, and accordingly proceed and then enroll with them for a medical program. Another question that we have in our hand, is it really required that you should be a resident of Australia to get the citizenship for the child, or an Australian citizen being a resident overseas in any other part of the country can also get the citizenship for the child, Australian child? Please put some light on it.
There's no requirement for you if at least one of the parent is an Australian citizen, except if the parent also obtains citizenship by descent, then you need to be a resident here for about 2 years before you yourself could sponsor your child for the process. So there's no residence requirement. You are, however, trying to bring your child into the country under Migration Act, and there are many visas. It could be adoption visa or child visa. Then it's a completely different matter. If you are adopting your child for whatever reason, because you're coming from a country without relevant court documentation, then it's not sufficient that you have a valid adoption in that country. You need to have resided overseas for 12 months before you lodge the application. And the decision maker needs to be convinced that the residence is not merely done in order to meet this requirement. It makes it all interesting because a lot of exemptions here. I suppose the question to ask really is whether both of the parents, or at least one of the parents, is Australian citizen. Then you focus on Citizenship Act. If there are questions and concerns about the citizenship status of the parent, then you have to start thinking about Migration Act.
Okay. Here there is a little bit of concern that I would also like to put across, that the Australian citizenship is acquired in different ways. You could be an Australian by birth, you could have acquired by nationalization, you could have acquired by descent also. So there are the particular application forms, and as per the Australian by descent, it's basically for them the Australian High Commissions overseas ask for a residence proof for a particular number of period in Australia. Otherwise, irrespective of the fact wherever you're staying, all across the globe, if you're an Australian citizen, you can very well get the citizenship for your child. Now we come to another question about a DNA mismatch, though it has already been put across to you by Mr. Roman that there are various grounds. The Australian High Commission is very sympathetic towards these concerns also. But I would like to share, Poonam and Roman, to share with the audience any experience of any particular case where there was a DNA mismatch and how the Australian High Commission or probably the Indian High Commission tackled the situation.
Okay, I can say that I did handle a case last year of an Australian citizen who had a DNA mismatch, and obviously said something. Oh, okay. So it becomes very complex the moment there is a DNA mismatch, as you all understand. And the parents who are hoping after 9 months they're going to get this baby delivered, and after a week they come to know that there is a DNA mismatch. So I hope everybody here understands what he would be going through. So similar situation happened last year, and it doesn't happen very frequently. As I was attending a session on the level 5, and they said like the best thing would be if parents would do DNA after 10 weeks of the gestation cycle, which is a good idea, and I would start recommending that to everybody, and that gives you at least surety that after 9 months this is your baby. And anyway you have to go through a DNA testing. If you go after 9 months, if you go after 10 weeks, actually decisions can be made that time. So we ended up with that case last year, and we contacted the High Commission. But first, most important was to understand from this parent if he would like to keep this baby, and his answer was yes, I want this baby. And so then we started working on counseling him how he could take, because as you all understand, India does not have a surrogacy law, so the baby does not qualify for an Indian passport. And if the baby does not qualify for a passport, it becomes very difficult for the baby to have a passport to leave the country. So we contacted the High Commission, and there were many counseling sessions going and the High Commission was very, very cooperative, and they met him privately many times, understood the whole process, and since he wanted the baby, so on humanitarian grounds, after 60 days, they qualified for a passport for the baby and happily returned home. But if you have such a thing happening, and if you think like there's some magic and the very next day you can leave like other couples are leaving, it won't happen. God forbid it should not happen to anyone. But if it happens, my only request is to keep patience, keep calm. Your government is supporting you. Indian government was also very supportive in giving exit visas without checking the DNA results, which was a good part. So all the governments are supporting, so we only request your cooperation to be calm if such a situation arises.
Under the Section 85 of Make It Up As You Go Along Act, the way that was resolved, because there's no genetic link, is the bureaucrats make a distinction between deliberately misleading them as to the absence of biological link, and those cases where it's unintended, it's unavoidable, and then they adopt a compassionate approach to that. Key difference, and indeed this is one of those cases where I got involved late December, when I was told that this lovely infant would be left in India. My sense of decency was confronted to think that she would be living her life in orphanage not because of her choice. So I asked the father, and the father made it very clear that he would like to keep the child, and we fought for it, and we got it in 10 days. If that is what we did there, is to illustrate that the intended father was a hands-on intended parent. The social aspect, in other words, we had to provide all evidence that there was even posting in Facebook, full anticipation that for all purposes, he was going to be the father of that child. And we got the child in 10 days' time. So that's a good thing. They're really sympathetic. Or indeed, there are instances where genetically it's impossible to have. Then you need to be upfront. And if that is the case, for one reason or the other, you need to be sure that you are a hands-on intended parent.
Very well said, Roman. This issue, which is a very sensitive issue, but has been very well answered by you, for the very fact that when we use the term intended parent and commissioning parents, the fact is that you have intended to become a parent. You wanted to commission surrogacy. So while the very fact that the criteria of having a biological child should not put across the rights or the claims of a child who you intended to bring to the earth, but the fact is that now the DNA is not matching and the child will be, being orphaned if not being claimed by the parents. But that's very right, and that's as a humanity, I think we all should have that sensitivity prevailing over our senses to keep in our mind always that we all should work together in the best interest of the child. Now, moving to the last question that I would like to ask from our esteemed panel is the fact that now Australia has introduced different state laws. But what is the criteria? Does the issue of the citizenship comes under the state law, or will the federal law prevail over it?
I would like to confirm to you that it is not the policy of our good friends at the Department of Immigration to cause troubles to parents. They will not report you to the state authorities so that you'll get into trouble. The problem, of course, is if you put in a half-cooked citizenship by descent application, and the bureaucrats are not comfortable about it, they would suggest, as a last resort, that you obtain a court order. And why would you want to do that if you are from those states that would possibly cause troubles for you? So the whole idea is to ensure that you put the application in correctly. I always say to clients that it's a very simple process. You just need to be sure that that they're comfortable with what you're doing.
Okay, any questions from the audience? Yes, please, go ahead.
Just one comment. I'm asked, Roman and I ask frequently by clients whether they'll be arrested when they get back to the airport. You won't be. If you're from one of the three jurisdictions, Queensland, New South Wales, the ACT. But just to follow up that comment you just made, Roman, I certainly have had one couple who, and remember them, who were, the Department of Immigration did refer to police, and they'd gone to Canada, they'd done it all by themselves, they'd only got the 1 month visa, so the husband went to immigration to say we need a 3-month visa. They'd shipped the surrogate and her boyfriend out to Australia for a holiday, and within the hour of being at the Department of Immigration office, the surrogate and her boyfriend were arrested at Cairns Airport. So that's very much the exception. As it turns out, no one was charged for the offence because it was all outsourced to surrogates being in Canada. But that's certainly very much the exception, but it has happened.
Yes, please.
Also, a question: how is the DNA testing physically done? Is there a check-mark spot?
DNA testing physically.
Before you go to India.
Who would
Say it again, I cannot hear you.
The DNA testing for
How's it done?
the parenting, is it done with a swab inside the cheek? How's it done?
See, there are different labs. There are different labs in Australia. Some do the swab testing and some do the heel prick.
The heel prick, okay.
Yeah.
And what are the costs of which one's better?
Cost is every lab has their own cost. And the Australian High Commission or the government has accredited labs list, which is available on the website, and that is provided to you when you start the surrogacy.
Now, this is the Australian High Commission in India?
Everywhere, wherever the Australian High Commission is, they have a list of accredited labs who are based in Australia, and they recommend you to go to the accredited lab. So only the sample collection is done in India after the birth of the baby, and the parents can leave their DNA samples before they depart for the countries where they are doing surrogacy, be it India, be it Thailand, and after that, Australian High Commissions in their countries have designated or outsourced DNA sample collections to doctors.
So you do a DNA sample before you go to India?
Yes.
You can leave,
parents can do it. Yeah.
Parents can leave their samples here, either prior to their departure, or the samples can also be collected while they are in India or Thailand.
But if you do it here, you will save some time.
We've got time for about 2 more questions.
Yeah.
Can I just say, while we're at the subject of DNA, that if immigration requires DNA test, it is a prescriptive way. You can't just basically present any DNA test that you obtain any other way. And if there's no genetic link, whatever you do, don't submit to a DNA test. There's no power to compel you to submit to a DNA test. The only reason why that is the way to do it in India is that's the only means by which they could determine it, because there's no parental order.
Sure.
But if there's no DNA link, don't submit to a DNA test, because once it's there, it's already an evidence that would not work in your favor.
Absolutely. I would suggest the same thing. Yes.
Okay. Sorry, we have a further question.
Are there risks on the pregnancy having a DNA test?
Okay, the way you said that at 10 weeks, the pregnancy.
Yeah, that's what I said. There are not risks because, as I said, the percentage of DNA mismatch is very low. And in 365 days, I've only handled 1 case of a DNA mismatch, so you can understand. But still, for security reasons, I would suggest DNA testing, if possible, could be done after the 10 weeks. So get it done.
Okay. One more question.
Miscarriage because of that.
Yeah, cause of miscarriage.
Yeah, so maybe probably the medical practitioner would be able to answer this question better.
They were answered.
Yes.
I just wanted you to expand a little bit on what if you go into it knowing that neither parent is going to be genetically related.
India, India doesn't. If you are going to India, then you have to. One parent has to be biological. That's the standard rule. Probably for the other countries, do you have any experience of Thailand and other nations? If there's none of the parents is biological, it's a complete donor program. So will they be able to get the baby back?
I confirm that I got a couple of cases, and it would possibly.
Is it an adoption situation, or would it be or you can still have it as a parenting situation?
It may be still possible through citizenship by descent, because as I said, biological link is not the exclusive and only way of proving the parent-child relationship.
If you do it in Nepal, like they're saying that in Nepal you can put your name on the birth certificate even if you're not biologically aligned to that child. Is that right?
And perhaps I could clarify as well that whatever you put in the birth certificate they certainly go beyond what's on the birth certificate. So it doesn't mean that if you manage to get your name in the birth certificate, that's the end of their inquiry. That is not the case.
Well, everyone, I'd like to thank Radhika, Roman and Poonam. That's been a really interesting